Hi friends, today we are going to discuss about Mental Health Care Act of 2017. I am Dr. Suresh Bada, Professor of Psychiatry and also Head of Telemedicine Center, Head of Forensic Psychiatry Unit at NIMANS, Bangalore. I have done my PhD in Law from National Law School. My PhD was on mental health legislation. So these are my credentials to discuss about Mental Health Care Act. Before I start my presentation, I would like to have a disclaimer. Basically, this presentation is academic in nature only. This is not a legal opinion. If you would like to have a legal opinion, please do contact an advocate. I'll repeat, this is not a legal opinion. If you want a legal opinion, please do contact an advocate. Conflict of interest, none. So Mental Health Care Act of 2017 was signed by the President of India on 7th of April. This act came into picture because of our commitment to UNCRPD. UNCRPD is United Nations Convention on Right to Persons with Disability. This was signed by our country on October 2007. Since we have signed UNCRPD at the international forum, now we have an obligation to align our national legislation. That legislation is Mental Health Act of 1987. Hence, Mental Health Act of 1987 was supposed to be amended. Since amendment was so much, the new law was written. That is Mental Health Care Act of 2017. If you look at the older legislation, the first one is ILA 1912. That is Indian Lunacy Act of 1912. This legislation was basically custodial in nature. That means patients were kept here. No treatment was given. Basically, there was no treatment available at that time. The next legislation came was in 1987. That is Mental Health Act of 1987. Here, the main focus was on treatment because there were new treatments were available during 1980s. But however, the rights were not given much importance. Culmination of all these things led to UNCRPD and subsequently Mental Health Act of 2017. So today we are going to discuss about Mental Health Care Act of 2017. This act preamble is very clear. The preamble very clearly says that this act is written to provide mental health care and services and also to protect, promote and fulfill the rights of persons with mental illness during the provision of the services. So the point is very clear. Providing services and protection of rights during providing services. So these are the two important agenda was kept when this legislation was drafted. So this has 16 chapters, 126 clause. Of course, the chapter 2 discusses about the definition like any other legislation. The chapter 3 discusses about the how to determine mental illness. 4 is basically on mental capacity assessment. So that has been defined. But the significant paradigm shift starts from Section 5. Section 5 to 13 talks about advanced directives. In India, there is no much importance given for advanced directives for persons to write about how he should be treated. For persons with mental illness, advanced directive has been drafted. Every person, excluding minor, has a right to draft an advanced directive and register under Mental Health Review Board. What he has to do is, the person has to write how he has to be cared and treated if he develops mental illness, and also how he should not be cared and treated if he develops mental illness. And this advanced directives will kick in only when he loses capacity. Even if a person has drafted, registered the advanced directives under Mental Health Review Board, and if he has capacity, this advanced directives will not kick in. It will start only when the person loses his capacity. The doctor has to look into the advanced directives and fulfill the wish written in the advanced directives. So the family members are responsible for providing this advanced directive when the person is admitted. If this advance directive is not provided to the doctor, then the doctor will not be held responsible. At the same time, if the doctor is following the advance directives and if some side effects or something develops, the doctor will not be held responsible. So that is the beauty of advance directives of Mental Health Care Act of 2017. Coming to the next, section 14 to 17 talks about nominated representative. Mental Health Care Act takes a one step ahead, telling that majority of the time the persons with mental illness rights are abused by the family members. Hence, it gives a provision from section 14 to 17 to appoint a nominated representative. This person is going to decide about how he will be treated if he loses capacity, apart from the advance directives. So this NR can be appointed if he is not a minor. And any person above the age of 18 can nominate a NR, but the NR also should accept that he is going to be deciding, helping him in decision making during the developing, when he develops mental illness. When there is no NR is available, who are the lists available in the Mental Health Care Act? If he has written NR, he will be the first choice. The next is a relative, of course, a family member, the relatives. Third one is a caregiver. Any suitable person, fourth, nominated by the Mental Health Review Board. If no suitable person is available, the Mental Health Review Board will appoint a director of the Department of Social Welfare or a designated representative from the Director of Department of Social Welfare. These NR are responsible for taking decision for persons with mental illness, helping the persons with mental illness to take decision, asking for what are the clause he has been admitted, treatment procedure, giving consent. But however, please do remember, NR is not a blanket proxy decision making entity. He has to take the wishes of the persons with mental illness, his background, his culture, his advance directives, and a collective as a person, what does he represent? That should be the NR's representation. And it is assisted decision making or a supported decision making that is entitled under NR. With this, section 18 starts. This is the heart and soul of the whole legislation. It starts from 18 to 28. The first time an health legislation enumerates the rights of persons with mental illness. And that is the beauty of this legislation. Section 8 talks about rights of persons with mental illness, basically right to access mental health care. This is a groundbreaking decision was taken by the Parliament of India. So, right to access mental health care is a right now. So that means a person who does not get this access to mental health care, he can go to the court and say, I did not get the treatment from this hospital and I need to be compensated. And it is justiciable right now. That means state government cannot say, I don't have psychiatrist. They have to hire a psychiatrist now. They have to have a clinical psychologist. They have to have a psychiatric social worker. They have to psychiatric nursing. They cannot refuse providing access to mental health care. It is for every person. It is not just only for persons with mental illness. Every person has right to access for mental health care. Those are inpatient, outpatient rehabilitation services. There are a range of rehabilitation services have been given. All those has to be provided. Not only that, it has to be affordable cost, quality, and in quantity. If you can't provide, the state doesn't provide, compensatory mechanism has to be given. If a person doesn't get treatment in one district and he goes to the next district and gets the treatment, whatever the cost, it has to be borne by the state for not providing this right to access for mental health care. Free treatment has to be given for BPL, that is below poverty line, and destitutes. And it also talks about long-term care if there are no family members or he is a destitute. So that is the beauty of this legislation, my dear friends. Coming to section 19, it talks about right to community living. Many of persons with mental illness are dumped in various mental asylums mental health institutions, or else even in various Nirashrita Parihara Kendra or beggars colony. Now this right says that they have a right to live in community. If the family abandons them, a legal aid has to be given from the state legal service authority. That means a person with mental illness, if his property has been taken away, he can request for legal aid and the state has to provide free legal aid. At the same time, he does not have any place to say. The appropriate government has to provide halfway home and other group homes or sheltered homes or supported accommodation. That is the duty of the government. So again, Section 19 gives an amazing rights. Section 20 talks about right to protection from cruel, inhuman and degrading treatment. Of course, dear friends, if you had been to various mental hospitals run by various agencies, state, NGOs, they're in a pathetic state. In some of the state, it is worse than prison. I should not compare, but I have been forced to compare this. That is the reason this section has been put. So a person with mental illness, when he is admitted in a various mental health institutions or establishment, he has a right for safe and hygienic environment, adequate sanitary conditions. Let me tell you, some of the mental hospitals do not have adequate number of toilets. The patient has to stand in the queue in the morning. That is the state of affairs. They should have leisure, recreational, education and religious practices in various mental institutions or establishment. Privacy and clothing. Many a time these mental asylums used to give a single uniform. That has been abandoned, and now a person with mental illness can bring his own clothes and wear inside the institutions. And he should not be forced to do any work which he doesn't like it. If he is being given a work as a part of a rehabilitation, a remuneration has to be given to him. And adequate provision should be made for preparation for living in the community. That is also a right. At the same time, adequate food has to be provided. And my dear friends, let me remind you, there were many mental hospitals till date do not provide sanitary napkins for our persons with mental illness, especially for women. So you can't imagine, that's the state. No compulsory tonsure. Earlier, whenever a person is mental illness is brought here to the mental hospital, they used to tonsure, considering that their hairs are matted. But however, compulsory is not done. But however, for the reason of hygiene can be done. But it has to be justified. There should be logical reasoning. You can't just do tonsuring for everyone. And the persons with mental illness can wear his own clothes. And also, he should be protected from all forms of exploitation, physical, verbal, emotional, and sexual abuse to be prevented in persons in mental health establishments. And the Section 21, this is a very common which occurs whenever the meager resources are given for mental illness. It has been taken away by the physical illness. So right to equality and non-discrimination has been given under Section 21. That means mental illness has to be given equally importance with the physical illness. That is what it says. At the same time, it is the obligation of the state government to provide emergency facilities, emergency services for mental illness such as ambulance and adequate appropriate living condition similar to physical illness. Many states refuse to take persons with mental illness in the ambulance. For that reason, this has been given. At the same time, many insurance, especially health insurance, mental illness was an exclusion clause that has been stricken down. All insurance companies has to provide mental illness similar to physical illness. That is the reason Section 21, right to equality and non-discrimination, plays an important role. Coming to right to information, a person with mental illness and his nominated representative shall has the right for the following information: reason for admission, review for admission procedure, treatment procedure, and language. And it has to be given in the language of the person with mental illness. Please remember, don't confuse with Right to Information Act. This is right to information, why he has been admitted, under what section he has been admitted, what are the admission procedure, what are the treatment procedure given, and it should be in the language of the persons with mental illness. So that's what it is section 22 talks about. Section 23, right to confidentiality. Every person who is working in mental institutions and mental health professional has a duty to keep the information confidential regarding a person with mental illness. However, there has been exceptions. The information can be shared with NR, other mental health professionals to provide care. If a person with mental illness is dangerous to self and others, then again, the confidentiality can be broken in medical emergencies, in the interest of public safety and others. Again, the confidentiality can be broken, and during the judicial proceedings, especially appropriate concerned statutory bodies are asking for information, you may have to provide. Coming to the restriction on release of information in respect to mental illness, that is section 24. No photograph or any information relating to persons with mental illness undergoing treatment at the mental health establishment shall be released to media without the consent of persons with mental illness. That means nobody should release the photograph of persons with mental illness to the media without his consent. Coming to the section 25, right to access for medical records. So here, this right is given only for persons with mental illness. The person with mental illness can access for his basic medical record. The basic medical record is basically has been mentioned in the rules. There is a pro forma for applying it, and there is a schedule which has to be filled by the person, by the mental health professionals, and the records has to be given. But however, it can be withholded. If he is going to withhold the information from the persons with mental illness because there is a possibility it may harm him or else it may harm somebody else, then the mental health professional has to inform the persons with mental illness that you have a right to go and apply for mental health review board. The mental health review board can now order the mental health professional to provide the records, or it may say no. Considering the reasons what has been cited, they may refuse to give the records. Coming to section 27, right to personal contact and communication. Many places, especially in the mental health establishment, persons with mental illness are not allowed to communicate outside or stop anybody from coming inside or stop them for communicating with them. In this section, a person with mental illness admitted to mental health establishment shall have the right to refuse or receive visitors, or to refuse or receive and make telephone or mobile phone calls at the reasonable times subject to norms of mental health establishment. That means person with mental illness has a right to use mobile phone, but however, he should not disturb others, not only within the premises of the institution, outside. So that's what it says. There is a reasonable restriction has been placed according to the norms of the mental health establishment. Coming to section 27, right to legal aid. This is very, very essential. That means person with mental illness will receive free legal aid if he has been detained against his wish and will, or else any rights have been violated. State Legal Service Authority, District Legal Service Authority, or the Taluk Legal Service Authority has to provide services, free legal services. That is what is right to legal aid. At the same time, it is the duty of the magistrate, police officer, person in charge of the custodial institutions has to tell that he has a right for free legal aid and he can exercise these rights. Coming to the section 28, that is right to make complaints about the deficiency of services. This rights has been given to persons with mental illness. He can give complaint first to the medical officer in charge of the mental health establishment, or else to the nearest mental health review board, or else to the state mental health authority. On this priority, he can give complaints and ask for the deficiency of services to be rectified. There are some implementation authorities. There are 3 important authorities have been there, which has been mentioned under the Mental Health Care Act. One is Central Mental Health Authority, State Mental Health Authority, and Mental Health Review Board. The Central Mental Authority and the State Mental Authority, these are executive in nature. Basically, they implement Mental Health Care Act. Whereas Mental Health Review Board is a quasi-judicial body which regulates, which monitors the implementation of Mental Health Care Act. It also looks into basically whether how the advanced directives are made, whether the advanced directive has to be reviewed, NR has to be reviewed, and if there is any kind of rights violation, MHRB is the one which is going to look after it. That is Mental Health Review Board, which will be formed at every district level. At least every 3 districts, one Mental Health Review Board has to be formed. That's how the central rules have been written. Coming to the mental health establishment, any place apart from the residence of a person with mental illness, if he is going to stay overnight, they have to register, and that is called as mental health establishment. And there are 2 types of registration. One is provisional registration and permanent registration. And this registration is very, very essential under the Mental Health Care Act. Because if a person is detained in a place, it is against the Constitution of India. But it can be detained by a procedural law. Mental Health Care Act is a procedural law. So you can detain a person if you have registered, and you have to follow the procedure. So that procedure is admission. Admitting a person against his wish and will is considered as supported admission. Earlier it was called as involuntary admission. So supported admission has 2 clauses under Section 89 and Section 90. Section 89 is less than for 30 days. Section 90 is for more than 30 days. So this is how the admission of a person with mental illness is done. One is voluntary or independent admission. The other one is supported admission, or call it as involuntary admission. If you are doing a independent admission or a voluntary admission, under Section 86 it is allowed. A person who wants to take treatment will give an application, and the person in charge of mental health establishment or a doctor or a medical officer will decide whether he requires admission or not. On that basis, he will be admitted. If he is a minor, and independent admission is allowed if the family members, that is parents, or the legal guardians, basically here it is called as nominated representatives, will apply for admission. Again, the doctor or the mental health professional are going to review, and they will admit the person with mental illness, especially the minor. This is voluntary admission, or also called as independent admission. Coming to supported admission, here it is involuntary. As I told, it is Section 89 and Section 90. 89 is less than 30 days, 90 is more than 30 days. So request has to be provided by the nominated representative. Once the request has been given under Section 89, less than 30 days, that has to be done by a mental health professional and a psychiatrist for admission. If the person has to be admitted for more than 30 days, that is under Section 90, 2 psychiatrists has to examine and provide opinion that he requires admission in a mental health establishment. However, in all types of admission, the mental health professional in charge of the mental health establishment need to inform the mental health review board, especially for women and children within 72 hours. For men, it is 1 week. And there is one more clause which is very essential for emergency treatment, that is Section 94. Any medical treatment can be given in any place without looking into the advanced directives. And that treatment should be immediately to prevent the dangers to self or others or to the property. And it has to be imminent, immediate. But if the NR is available, you have to take the informed consent. This emergency treatment can be given in anywhere in the community, need not be in the registered mental health establishment. And it lasts for only 72 hours. I repeat, this emergency treatment, it is not emergency admission, emergency treatment. It is given to immediately necessary to prevent the danger to self or others, or person causing serious damage to the property belonging to self or to the others, and which the behavior will be directly flowing from the mental illness. It is not because somebody wants to damage a property during riot. That is not applicable here. It has to be directly flowing from this mental illness and lasts for 72 hours. There are certain restriction and prohibition has been done under this legislation. They are called as prohibition and restrictions. No psychosurgery can be provided. Yes, if it has to be done, it has to be with the consent and the mental health review board clearance. At the same time, persons with mental illness cannot be restrained. If it has to be restrained, it has to be done by the order of a psychiatrist. And it has to be done only to prevent imminent and immediate harm to self or others. And it has to be as less time as permissible. Whichever restraint has been done has to be intimated to the mental health review board monthly. Unmodified ECT, electroconvulsive therapy, has been totally prohibited. Modified ECT has to be given. At the same time, sterilization, that is basically stopping from reproduction, is completely prohibited. That means just because a person has mental illness, you cannot do sterilization. Chaining, seclusion, solitary confinement has been completely prohibited under the Mental Health Care Act. At the same time, electroconvulsive therapy for minor can be done only with the permission of the board. Without the permission of the board, ECT for minor is prohibited. At the last part, section 115 decriminalizes suicidal attempt. Section 115 clearly says that a person who attempts suicide shall be presumed to be suffering from stress at the time and will not be punished under the Indian Penal Code section 309. That means if a person has attempted a suicide, there will be no section 309 will be pressed. By default, it will be considered as stress. If there is a contrary evidence is able to be proved that he did not add stress, still section 309 holds good. Summary and conclusion. Dear friends, Mental Health Care Act has been in India has taken a massive step in the rights direction for health legislation. It's a rights-based approach in a right direction for the commitment of providing mental health care to persons with mental illness. And this gives enormous power and rights to persons with mental illness. My dear friends, please do follow Mental Health Care Act and help our persons with mental illness. If you like this presentation, please do subscribe to the channel. Please click the thumbs up and also follow me under this YouTube channel. Thank you very much.